We're here this morning for oral argument in, it's Henke or Henke versus Hospital et al. It's our number CV-24-0259. Each side has 20 minutes, as you know, and you may keep whichever time you'd like, but you have to keep your time yourself. So please proceed. Pardon me?
Oh, no.
There's a timer up there for you, so yeah.
But keep your time for rebuttal.
Right, sorry,
yes.
yeah, just whatever time you'd like to reserve. If you want 5 minutes or whatever, you're kind of responsible for stopping. Otherwise, we just keep asking questions. So.
Okay.
Please begin.
Thank you. Elliot Wolf, on behalf of the plaintiff appellants, Margie Henke and her daughters, Emma and Letitia.
And Mr. Wolf, could you pull that microphone a little closer? They always put a little far away. Thank you.
Yes. The defendants and their amicus hospitals and insurers have had the dual protection of 12-563 and 12-572 in every case against emergency services providers for the last 16 years. And in the first instance, that protection comes from the court because if the plaintiff cannot produce a qualified expert to testify to the necessary elements of a medical malpractice case, which are that the defendant's negligence was a probable or likely cause of injury or death, and connect those dots, then the court will grant summary judgment or directed verdict. In this case, if the plaintiff does have, as the plaintiff did have in this case, sworn testimony from a qualified expert that the defendant's negligence was a likely or probable cause of injury or death, the additional protection comes from the jury, which is told by instruction, consider and weigh all the evidence, determine the credibility of the witnesses, and then tell us whether you believe that that proof of the defendant's negligence being a cause, approximate cause, of the injury or death is clear and convincing or highly probable.
Mr. Wolf, go ahead.
Sure.
Go ahead. Well, the counsel, it seems to me, drilling down on this, that we have a situation under 563 where you have to show at least as one of the elements proximate cause. And we've said that in Sampson and in cases before that, that is the continuous string of things and essentially but-for causation. But in medical malpractice cases, you have to show that it probably was the cause of the injury or death. It's odd then when 572, you have to show that by clear and convincing evidence, which the cases have said, well, that means highly probable. So it begs the question, for me at least, if you have to have an expert say that it's at least probable, do you need that expert to also say highly probable, because it would be, as we said in Sampson, it would be beyond the jury's expertise without some guidance from an expert to make that assessment and come to that conclusion. So could you address that?
Sure. Well, first of all, unlike, if I can go back a second, unlike in Sampson, unlike in the string site cases of the defendants, Seisinger, Kreisman, Barrett, there was no qualified expert in those cases, either on standard of care or causation, or none at all. And in Sampson, the difference was there was a causation expert, but the causation expert couldn't say that the defendant's negligence was probably a cause. In this case, we have a highly qualified cardiothoracic surgeon who has connected those dots and made that connection of probability. So he's done what the plaintiffs in those other cases were unable to do. So that the jury in this case didn't have to guess or infer or speculate about whether or not there was causation. They would just have to decide whether the totality of evidence of proof of causation was clear and convincing. And if they decided that...
May I ask you a question on that point? And
Sure.
I want to go back a bit because you began by mentioning that there's sort of two levels of protection, one the requirement for an expert and then one of a jury. But as I think about this, and we talked about it a bit in Francisco v. Urological Associates, we referenced the fact that looking initially at the two expert statutes, 2603 and 2604 in Title 12, that they were part of a statutory framework in order to weed out frivolous claims in the medical negligence field. And if I keep that idea in mind, when I look at the fact that the legislature, for suits against emergency room physicians or emergency rooms, or in the emergency room context, has required a plaintiff to be able to establish their case with clear and convincing evidence. My question is this: why wouldn't we take that into account and say that, well, the fact that a prima facie case for regular medical negligence, as the chief was alluding to, just requires an expert to say probable in establishing causation between a failure to adhere to the standard of care. If we're now dealing in the emergency room context, why wouldn't that clear and convincing standard apply to establishing a prima facie case? Because I hear you, and I understand your argument to be that, well, that clear and convincing standard of proof is what the jury considers, and that's part of the jury instructions. But for this regime of wanting to protect medical providers that the legislature has determined, why wouldn't that clear and convincing standard also be part of the prima facie case?
Well, because it's part of the burden of proof. That's the jury's
But what I'm asking you is to make that distinction.
Exclusive domain.
Well, and what I'm asking you to do is say, okay, I get that, but why don't we take into account that just as the legislature is looking to require a prima facie case in a medical negligence, regular medical negligence case to be, for preponderance of the evidence to be probable, why would we ignore the clear and convincing standard in the statute and leave it for the jury and not consider that in the prima facie case as well?
Right. Well, I guess there's two main reasons, if I may. I think, first of all, probably best said by the quote from Justice Harlan in the Renforth case: the jury can only acquire a belief in what probably happened. The jury's decision whether the burden of proof has been met, whether it's a preponderance or clear and convincing or beyond a reasonable doubt, is a reflection of the fact finder's belief in the correctness of their factual conclusion. In this case, we've cited to you at least 3 Arizona cases, they've cited none, in which the courts hold that if there's a burden of proof, as in this case we concede the burden of proof is clear and convincing, that is exclusively an issue for the finder of fact, and testimony, if you look at the MH207 case or the Renforth or the Thompson versus Betterbilt or the 2 other jurisdictional cases, Irby and Lilly we cited, medical testimony on probability is sufficient for the finder of fact, evaluating the evidence as a whole, which is what the Raji Standard 3 requires them to do, to decide whether the totality of evidence is clear and convincing and highly likely, even beyond a reasonable doubt.
Well, let me stop you there. To what extent is it appropriate for us at this stage, or for a trial court at the summary judgment stage, to consider the totality of the circumstances in the prima facie case analysis?
Well, I guess the answer is that's exclusively an issue for the jury, and this court itself has reminded us that the judge is not a finder.
But we don't get to the jury unless we've got a prima facie case. So my question is, can we consider facts beyond the medical expert at the prima facie to determine whether there's a prima facie case?
Can you or can the trial court?
Well, I think we're basically determining whether the trial court got it right or not.
So I'll answer that as far as the trial court is concerned. This is why this court has reminded us in the Thompson versus Better Build case in Orm School, the judge is not a fact finder. And where there are other facts, in addition to expert testimony, as there were in this case, from which reasonable jurors can find clear and convincing evidence, viewed in the light most favorable to the plaintiff, summary judgment or a directed verdict must be denied. There were compelling facts in this case, and I can recite them quickly. The defendant, you don't need me to do that?
I think we're good.
You're good on that?
Yes.
Yes, okay. So what the defendants are trying to get you to do is to continue to conflate the court's gatekeeping responsibility to make sure that the plaintiffs have expert proof of probable causation, which we had in this case, and they're conflating that with the jury's exclusive fact-finding function to decide whether or not the totality of evidence makes it highly likely, clear and convincing, that the defendant's negligence was a proximate cause. By the way, the defendants have cited, for example, Stafford versus Burns. Understandably, they did not discuss it. And the reason they didn't discuss it is because in that case, and it's the only 572 case that I could find, and they cited it, but they didn't discuss it. In that case, what happens is the case goes to the jury in a case against an ER doctor, and the jury is instructed under 572, they have to find this heightened burden of proof in an ER case. Do you find it after considering all the evidence? And the jury says, no, we don't think this rises to the heightened burden of proof, which, by the way, happens, as you can imagine, quite a bit. It's often the case. So if they find that, as they have for the last 16 years under these circumstances, then they return a verdict in favor of the defendant. And that's what could have or should have happened. They should have gotten this case here. And you would think that the defendants could find one single case in Arizona or elsewhere that holds as a matter of law that the jury or the fact finder isn't allowed to see or hear any of that other evidence that I was going to recite to you, but you've read, to decide whether the totality of evidence is clear and convincing, unless the plaintiff discloses an expert who, by the way, doesn't see or hear all the evidence, can't comment on credibility, but they have to, what they want us to do is say, well, you have to get that expert to tell the jury that the evidence is clear and convincing.
Well, and Mr. Wolf, let me take you back to my first question, because I'm not sure I really got an answer to it, so I'm going to approach it a little bit different way. That is that we've said that you need an expert to at least show probable cause, or not probable, proximate cause, showing that it's probable that the act or omission resulted in the injury.
Yes.
The reason for that is because it's simply outside the jury's common experience to be able to make that judgment. So that's why you need that expert evidence. So with that in mind, when you're required to show that the act or omission proximately caused the injury and that it's highly probable, is it within the jury's expertise to make the decision that it's not only probable that it caused it, but it was highly probable, or is that something that would be, as we said in Sampson, speculative, and you need an expert to actually say that?
No, the burden of proof is exclusively in the jury's. And I can't remember if it was Irby or Lilly or one of those cases specifically addresses that and says, in a case like that, it's not only the expert opinion, but it's all the rest of the facts that determines whether or not the burden of proof has been met, even if it's beyond a reasonable doubt. So,
So it would be up to the jury, I mean, it sounds odd, but it would be up to the jury to decide, do we think it is highly probable that all of the evidence shows that the act or omission probably caused the injury?
well,
It's an odd way to say it, but isn't that what we're
yeah,
ultimately coming down
right.
to?
Was the totality of evidence to us clear and convincing that the defendant's negligence was a probable cause of the injury? And clear and convincing is defined as highly likely. And by the way, in Ray Leon G., before I forget, this court, looking at the definition of likely, actually adopted the Merriam-Webster first definition of highly probable. It certainly likely means at least probable, if not highly probable already in that opinion. Well, you would think they would be able to find one case that negates the holdings in MH 2007 and Renforth. They found no such case. You'd think that they'd have found a case that says, you know, I mean, for example, a forensic expert in a criminal case can't testify, give his opinion, and say, hey, you know, I'm convinced that the burden of proof beyond a reasonable doubt has been satisfied. It's no different in the civil cases, as we've shown in Webb, for example, which says those opinions in a civil case are excluded. They invade the province of the jury. They just tell the jury how to decide the case. So they haven't found a case. The reason is, on either of those issues, there is no such case. That case doesn't exist, and they've not cited one.
And to be clear, the summary judgment motion here, as I see it, was simply not on the totality of the circumstances. You can't show by clear and convincing evidence your case, but simply that because you don't have an expert affidavit that says that, they are entitled to judgment. Is that right?
Yes, exactly. The trial court said Dr. Marmorenu's opinion is admissible. It's the jury that decides, and I'm quoting from the opinion, it's the jury that decides whether or not the burden of proof has been met, and then granted summary judgment solely because the plaintiff's expert wasn't disclosed to say highly probable causation instead of probable causation, and then leave the rest of the facts to the jury.
And Mr. Wolf, if I want some clarity on the record here. Is there anything to establish that Mr. Henke's condition was so severe on the day of that ER visit that he would have passed anyway, regardless if treatment, if there was testing and treatment that day? Is there anything in the record that was provided by defendants?
The simple answer to that is no. The only thing in the record is our expert's opinion that if the defendant had complied with the standard of care on the day that she saw him, he would more than likely have survived. That was the original declaration. And he survived for 5 more days after he was sent home being told he had a virus and not endocarditis.
You want to save the rest of your time?
I would.
Okay.
Thank you.
Thank you. Is it Mr. McLaren?
Good morning. May it please the court and counsel, my name is Michael Ryan, and I represent Dr. Chowdhury in this matter. For over 50 years, Arizona medical malpractice law has always required expert testimony to establish proximate causation. It's part of the prima facie case. You have to have it. And if you don't have that expert testimony for over 50 years, that has not allowed the plaintiff to get to the jury.
Now, you just used a phrase, part of the prima facie case. And what I am wondering here, I agree with your opposing counsel that the facts are compelling here. You know, with the urgent care calling and giving Mrs. Henke a note, which she passes to the doctor, and the doctor puts it down and says it's not that. A couple days later, he dies of that. That, to me, comes awfully close to a jury being able to infer from those facts causation. But you're arguing for, you know, a very, very strict standard where if you don't have the precise expert testimony, no matter how compelling your facts are, you don't have a prima facie case. And so, is that so? Where are we mandated to apply that rule?
Thank you, Your Honor. And Justice Bullock, that's absolutely correct, is that there's standard of care, and frankly, the items that were pointed out by Mr. Wolf in his brief are standard of care items. You can't conflate the two. And we'll get to what 12.572 says, but you can have a very compelling standard of care case and not have a compelling causation case. What happens in that situation with the jury? Are they going to be unduly influenced by the standard of care? Of course they are. That's why the elements are separate. You don't just have to prove standard of care. And I was before this court in the Sampson case. And that's what the Court of Appeals held, is that they held, listen, if you prove this poor young guy, this young kid, if he would have been kept for 3 hours and that violates the standard of care, then the jury can infer causation. And this court said in no equivocal terms, no, you can't. You have to have expert guidance. Why? Because that aspect of medicine is not understood by laypersons. It simply isn't. And let's take this case. We have the date of May the 4th. I think I'm speaking the right date there. But there was endocarditis at that time, but would it have made a difference? And Justice King, you asked that. Would it have made a difference? Well, the bottom line is, if an expert can't say that it's highly probable that it would have made a difference, how can you allow laypersons who don't know, who have no clue, to make that inference?
Well, let's sift through that, because
Sure.
that's really, at least puts the finger on the issue for me about the extent to which an expert must opine. Would you agree that here, if this wasn't an emergency room situation and it was a preponderance of the evidence standard, that the expert affidavit was sufficient to show proximate cause?
Absolutely.
Okay, so
There's no question.
we're really just talking about whether the expert needs to show high probability or not. I'm taken by Mr. Wolf's argument that is there a conflation between the standard of proof with what needs to be shown, the elements of the cause of action, which is proximate cause. And proximate cause is, as you well know, from Sampson and other cases, continuous, unbroken chain of events that leads to the injury, and it's a but-for kind of causation. And we've said in MedMal, it probably was the reason for the injury. So if you say that the expert needs to say highly probable, what's the need for that? Why is that outside the jury's ability to comprehend if they're truly convinced or not, and to what extent? And two, doesn't that effectively change 563's elements, at least what needs to be shown by expert proof?
Thank you, Justice Timmer. No, it doesn't change the elements, and the reason it's required is the same reason that possibilities can't be used to meet the probability standard in a preponderance case. And this court, back in 2009, this court said that expert testimony on causation is a substantive component of the common law reflecting a policy decision that the plaintiff's substantive burden of production could only be met by a particular kind of evidence. the burden of proof is not just the jury burden of proof. There are two components to it, and I thought that the amicus brief of the hospital and insurers did a good job of explaining that. There's a burden of production. And for, like I said, over 50 years, if the plaintiff only had possibility evidence and not probability, if the expert couldn't say to a reasonable degree of medical probability, this standard of care violation caused the injury.
But here's the difference, that the difference between possibility and probability means that, you're correct. They haven't made that threshold required by 563, which is a showing of proximate cause. The difference between probability and highly probable is different, because proximate cause, as you said, it's shown certainly by a preponderance. So the difference is, why the extra? That's the difference. And cases have said that I can't pronounce it, but James versus Crippen,
Yes.
from the Court of Appeals said, at the point in time when the jury might not be competent to determine medical malpractice without the aid of an expert, that the physician fell below the standard of care. But after that, the nature or the gravity of the deviation, whether it was simple negligence or reckless disregard of the safety of the patient, that's within the jury's ability to come to a conclusion about. So why doesn't that, either they're really convinced that proximate cause occurred here, or versus, well, all right, we're convinced?
Because that's what the legislature did when it raised all of the components, not just standard of care, Your Honor, all of the components to clear and convincing, including proximate causation. So how does a plaintiff prove proximate causation? What I was pointing out that this court said in the Seisinger case is, that's the only way you can prove proximate causation is through expert testimony. And so if the legislature is saying you have to prove it to a clear and convincing degree, the only way that can be proved is through expert testimony, that it's highly probable that this result would have occurred. And if you look at all of the policy reasons that were cited in detail by the amicus briefs, it's a scary time for Arizona in emergency medicine, and that continues. The reason the legislature elevated the burden of proof on causation is because it knew there was a universe of cases that it may be more likely than not, but an expert can't say that it's highly probable.
But you're not going to have, I'm taken by the fact, I was trying to think, in what other context would you have to have an expert talk about the burden of proof? So, for example, in a criminal case, the person taking the DNA or the person that is doing the fingerprint analysis is going to say, this is what I conclude, but they're not going to say, beyond a reasonable doubt, this is this guy's fingerprints. That's up to the jury to look at all the evidence, and then they can decide, well, maybe this forensic guy doesn't really know what he's talking about, his education wasn't enough, et cetera, et cetera. Why in this context couldn't you have, as a threshold, the expert says, yes, it is probable, proximate cause is met here. It is probable that the act or omission caused the injury. Maybe they've got this great CV with all these credentials and experience and such, puts weight behind that to make it clear and convincing, versus this person's been out of medical school for a year, hasn't had much experience, still comes to the conclusion the jury could easily say, I don't find that clearly convincing, and reject it. Why isn't that the place in which clear and convincing, beyond a reasonable doubt, preponderance, all of that comes into play?
Because this is a medical malpractice case. And part of the prima facie burden has to be established through expert testimony. That's what Sampson said. That's what this court said. You can't allow a jury to speculate. And laypersons are not qualified to make that decision in medicine. That's why Sampson is such a powerful and correctly decided case. In a medical malpractice case, you have to have expert testimony to the quantum of proof necessary. Otherwise, you're allowing them to speculate between more likely than not and highly probable.
Counsel, let me ask you a question about that.
Sure.
Because as we've discussed, and you've raised Sampson and other cases in which we talk about what juries can't infer, if nothing else here, if you have an expert who's willing to say that there is causation, then the jury's not inferring causation. Rather, to the point that Mr. Wolf made, really at this point then, the jury's just being asked, as they're asked in any other type of case, to find whether or not the plaintiff has met their burden of proof to establish clear and convincing evidence that the injury occurred, given the elements. In other words, if we left things just the way they are, the jury's not inferring causation either here, and they're left with just having to determine whether or not the plaintiff has met their burden to establish the standard of proof.
Respectfully, Your Honor, that would gut 12572 in the intent of the legislature. Because, frankly, the legislature intended that expert testimony, that's what's required for causation. We all agree on that. And you can't get part of the way there with expert testimony and allow the jury to infer the remainder. That's very clear.
Are they really, excuse me if I interrupt, but are they really inferring the remainder, or at that point, and I think this was what Mr. Wolf was arguing, or at that point, aren't they carrying out the normal jury function? If you told them that the plaintiff had to prove their case with a preponderance of the evidence, they're going to do that. If you tell them that they have to decide the case based upon clear and convincing evidence, they're going to do that. No matter what we say about causation here, they're still going to get charged with having to find whether that standard of proof is met, correct?
What other evidence would go that's medical that the jury could infer would go to whether something's highly probable? None of the stuff that Mr. Wolf put in there is. That's standard of care stuff. There's only one question, and that is on May the 4th or March the 4th, I can't remember the date. On that day, if there would have been the treatment, and there are several levels of that given, would have the patient survive to a high degree of medical probability? What evidence can the jury use?
You know, there might not be any other evidence in this case. My concern is that, from my understanding, you didn't move for summary judgment based on all of the evidence, that even with everything read in the best light possible, there's simply not enough. And in great part, because of the expert affidavit. But my concern is saying that in all cases, at all times, you have to have the expert say it in the affidavit. And if you don't, you're out, despite what else is out there. And I don't know what else is out there, but that's what I'm concerned about, is that constraining it to that upfront expert affidavit only isn't supported.
If the expert can't say it, Your Honor, if the expert can't say it, how can you possibly allow laypersons not trained in medicine to infer it?
Suspending disbelief for purposes of a hypothetical, counterfactual to this case, and probably unlikely in the real world, but what if the physician who is subject to the malpractice claim in his deposition or had told one of his colleagues, I can't believe I just killed that guy. I should have done this test. He would have lived another 20 years. Can that overcome the failure of the expert to articulate causation by clear and convincing evidence?
You know, should have is standard of care, but he would have lived another 20 years. Certainly, that's a possibility. But here's the point, though. You have to have expert testimony to get the prima facie elements to the jury. If you don't, you can't. And if you don't have highly likely from an expert, you can't allow the jury to infer. It doesn't matter that later on other evidence could possibly, and probably wouldn't, but it could possibly come out. That's always the case with every summary judgment motion. Every time you move for summary judgment, whether it's a preponderance standard or a clear and convincing standard, there always could be later evidence that comes out. That's always a possibility. The point is, if the plaintiff can't get an expert to say that it's highly probable to overcome a summary judgment motion, which they didn't do here, then the prima facie elements have not been met. And under Sampson, it's required that summary judgment be entered for the defendant. My co-counsel probably needs some time, and I will cede the time.
As he's coming up, the next question I want to ask, so figure out who's going to answer this, is, okay, so if we make this declaration that in an emergency room context, you have to say highly probable, and I take Ms. Wolf's point too, that I don't think we have another case where we've said that in the emergency room context, and we now talk about applying this retroactively. I noted in your briefing that because there's this other affidavit out there, that it wouldn't be admissible under Rule 37. But I noted within that rule that there is an ability for a judge to accept it if it wouldn't prejudice the other party. If we're dealing with all the same evidence and the only thing that changes here is more likely than not to highly probable, how would the hospital be prejudiced?
We're going to tag team on this.
Okay.
Let him. Yeah.
Thank you.
Thank you, Your Honor.
If it pleases the court, Justice Montgomery, to answer your question, this wasn't an affidavit stage of the case. Full expert opinions had been disclosed pursuant to Rule 26.1, which required plaintiff to disclose all of their experts' opinions and the facts based thereon. So this idea that this was a preliminary expert affidavit that was moved for summary judgment under is not correct. The Rule 37 prejudice would prevent them because at that point, there is no good cause for disclosing new expert opinions after every other expert in the case had been disclosed.
But I guess my question is a little bit more nuanced, that if we were to agree with you that you have to say highly probable in the emergency room context, why shouldn't we give the plaintiff the opportunity to then go back and submit the affidavit that apparently they have on hand, and all that's changing here are the words that we're now saying must be there? Where's the prejudice in that?
I believe the court already answered this in the Razor case, that if a party opposing summary judgment does not have the evidence sufficient to overcome the motion for summary judgment, the exclusive remedy for introducing new evidence is Rule 56D.
And so, if I understand you correctly, then we're not making a distinction between an expert's assessment of the evidence and the evidence itself?
No. For instance, in Razor, this court decided that a defendant did not need to challenge an expert's qualifications prior to moving for summary judgment. And if the plaintiff wanted relief based upon that expert's lack of qualifications to offer their opinions, the exclusive remedy for asking for that relief is Rule 56D. That was not done here. That is why the court denied the motion for reconsideration, saying this could have been raised at 56D. Had Mr. Wolf submitted an affidavit and told the trial court what the evidence he wished to introduce in response to the motion for summary judgment under 56D, we would have had that argument at that time.
Now, you represent the hospital, right?
Yes, I am, Mr. McLaren.
We didn't give you a chance to introduce yourself. In your brief, you cite cases saying the following. Causation is generally a question for the jury unless reasonable persons could not conclude that plaintiff had proved this element, even incorporating the clear and convincing standard. Isn't that satisfied here?
No, it's not, Your Honor, Justice Bullock. It's not simply because we keep talking about causation if it's a simple thing in this case. It is not a simple thing. It's if Dr. Chowdhury orders this test, is the patient admitted? What modalities of treatment are administered? How advanced is the disease process? What would the imaging show? What would the laboratory test show? There's many things embedded within this. And plaintiff's own expert, Dr. Joseph, opines, as quoted by the Court of Appeals, that the failure to evaluate for endocrinitis is likely to deprive Mr. Henke of a chance of survival. However, he goes on to state, he himself, an expert in infectious disease, could not quantify the decreased chance of survival due to the lack of specialty consultation and medical or surgical intervention. If plaintiff's own expert can't quantify his opinion, asking a jury to infer from probable to highly likely is a step too far. That is not within their province, or not their province, their expertise. It is not for a lay jury to decide that. This is clearly expert qualifications.
If the expert had said in the affidavit that I find that the doctor fell below the standard of care and that failure approximately caused the death, would that be sufficient?
No.
Why?
I think that was the Beckendorf, similar to the Beckendorf case from the Court of Appeals. Beckendorf said a plaintiff can only introduce expert testimony that satisfies their burden of proof. Anything below that is inadmissible expert testimony from a plaintiff. In this case, likely testimony on causation would not satisfy plaintiff's burden of proof and would therefore be inadmissible itself. the defense can speculate on causation. And
I know,
sorry,
and you're
Justice
out of
King,
time.
I believe my quotation answered your earlier question
I
about.
think you're out of time, though, unfortunately, so,
Sorry.
thank you. Mr. Wolf, minute 49.
Well, first of all, I think it was Justice King who asked this question. Would it have made a difference? Plaintiff's expert says, yes, it would have made a difference. Greg would have survived. Let's say their expert says no. Well, who does the jury believe? It's a jury question. And how convinced are you that your conclusion as to whether or not it's highly likely, taking all the facts into consideration, how convinced are you of your factual conclusion? That's a burden of proof. That's not burden of production. That's clearly just exclusively a jury question. And I'm sorry, Justice Timmer, I said Webb before. What I was looking for was that quote from Jamas, which is exactly the one that you read, which says the jury is not incompetent, may be incompetent to figure out what causation is, but they're not incompetent to figure out whether or not the burden of highly probable or clear and convincing is. Clear and convincing, they want to say the legislature imposed this like it's the only type of case where there's clear and convincing burden of proof. There's dozens, if not hundreds. And in all those cases, some of which we cited to you, they've cited none, where there's clear and convincing evidence that's required. It's exclusively within the purview of the jury. It's not for the judge to decide as a matter of law. Last thing, Razor, as I recall, if I'm recalling it right, they challenged on 12-2604, but on remand, the court said, on remand, if a causation expert is needed, let him make a motion under 56, Rule 56. And
Mr. Wolf, just like Mr. McLaren, you're out of time.
Yes, I see. All right, thank you.
Thank you, though. Thank both counsel. Really excellent oral argument and briefing on this matter, and we'll take it under advisement and issue a decision in due course. We will not be adjourned, but stand in recess to have a change on the bench.